So thank you for not leaving when you had the chance to. Sorry if you're here by accident, but I am going to talk about some legal stuff to do with video games that I hope you'll find useful if you're making a game or selling a game or in any way involved in games. So my name is Pete, and I work at a law firm called Purewal and Partners, and we are dedicated to sort of interactive entertainment. So what does that mean? That means we cover things like video games, esports, digital broadcast, so that's things like Twitch and YouTube, and we help everyone sort of in the chain from making a video game or doing anything to do with esports. So we help game devs, we help game distributors, or anyone in between. And we do everything from contracts to dispute resolution, or setting up your company, or regulatory matters. So if you're like selling a free-to-play game, things you have to do to comply with that. And and that's basically what we do. And that's me and my boss there. I didn't actually make this picture for this presentation. I actually had that one already. So you'll see it's a bit of an interesting place to work at. And I'm going back here because I missed this slide. What I'm going to talk about is I'm going to go over some of the most common sources of headaches you're probably going to come across when making your game, and hopefully how you can avoid these. And then really quickly, because I appreciate time is ticking on, we're going to talk about a couple of other hot topics you might have heard about in the news, and then AMA if you've got any questions. So contracts. Contracts are the sort of lifeblood of business. And one of the biggest headaches is people not getting the right contracts in place. Or if you do get a contract, it's a bad contract. And I kind of understand why. I mean, contracts are complicated, they're potentially expensive to get, and even when you have them, sometimes you'll end up just sort of arguing about them anyway, so kind of what's the point? But the point I want to get across to you today is that contracts don't have to be like that. I mean, you really should just be saying what you want, what the other party wants, and what you're both going to sort of do for each other, what you're both going to do in exchange for the other person's like services. And importantly, you should also set down what you don't want the other person to do. So if you're making a game, then just get that on paper. I mean, it's going to be better than nothing. And unless you're dealing with a sort of like Minecraft-esque game or something on that scale, then you really don't need something like a gargantuan contract. So when would you need contracts? And like I said, pretty much at every point of making a game or setting up your studio or selling your game. So when you're setting up your studio, you'll have to incorporate yourself as a company probably. For reasons I won't go into now, but you'll probably want to be like a proper company entity. So you'll have things like shareholder agreements, which are the contracts in place between the owners of the company, just setting out what each person gets and does and stuff like that. And even if you're just making a game between a couple of friends, it might even be worth just setting down on paper who owns the game, how you're going to share money that you get from this game that you make, because it sounds stupid now that you're all good friends and nothing's going to go wrong. You're never going to argue about anything. But the truth is, down the line, you don't know what your mate's going to be doing. So get it on paper, and at least that's an indication of sort of who owns what. So there. Another time you'll need contracts if you're licensing in work. So if you are sort of working on a franchise game, so if you were lucky enough to get like Lego or something like that, and you were making a new Lego game, then obviously you'd have a license agreement there to use the Lego IP. Or alternatively, if you've made your game and you are wanting to let someone else port it to another console, or if you're wanting someone to make merchandise or advertising or things like that, you would give them a license of your intellectual property. So there'll be agreements there. Confidentiality agreements, they'll be sort of rife everywhere. I mean, whenever you're working with a publisher or a dev or giving your game to YouTubers, whatever, you'll probably want them to sign some sort of confidentiality agreement, saying they're not going to talk about the game before a certain point, or they won't go and sort of give all of your important information to anyone else. And again, setting up IP ownership is something I'm going to talk about on the next slide, but it's really, really important to be clear who owns the IP in your game. And lastly, selling your game. I mean, if you're selling it via like a distributor or an online platform, like Steam or anything, there's going to be contracts in place with publishers or Steam, whatever. So it's best to get a working understanding of contracts, no matter how much it's a horrible idea. Try and understand the contracts that you are definitely going to be signing. So for example, go on the internet, go find out what a liability is. Now, a liability is just kind of how much you might have to pay if something goes wrong, if you breach the agreement. Try and work out what a warranty is. I mean, you're going to be getting these things called warranties in contracts, and they're sort of promises or statements that something is true or isn't true, or that you will or won't do something. So try and work out these terms, get an understanding, and read whatever you are signing, really. And if you don't understand it, don't sign it before you understand it. So IP is the sort of legal container of your game. And a lot of times the IP in a game isn't protected properly. And people don't protect their IP because sometimes it's expensive, depending on the IP you're protecting. It's really confusing. Sometimes people don't sort of distinguish between the types of IP in a game properly. You don't think you need it, or you might think you get it automatically because you've made your game, so you should be able to protect it, right? Well, I thought it would be most helpful, rather than sort of going too in-depth, to just give you like a really brief overview of the IP, the types of IP that will exist in your game. So those 4 types of IP are going to be moral rights, patents, copyright, and trademarks. And we can deal with the first 2 like super quickly. So moral rights. If you make an asset or a piece of work, so say you do a piece of artwork for a game, or you make a soundtrack, or you do a bit of code or anything, you're going to get these things called moral rights in that piece of work. And moral rights are the right to be identified as the author of that piece of work. So if I make a piece of artwork, and I've made it for any of you, so I give it to you, you own it, but I have the moral rights in it, so I have the right to be identified as the author of that piece of work, so you got to give me credit. Now, normally, the agreement between us that there will be, or should be in place, will sort of waiver these rights, so I don't really, in practice, have the right to sort of be attributed it, but legally, by default, I do. Patents. Not really relevant to games, so I'm going to skip them over here. They're really complicated, they're really expensive, and they're not really too relevant to games. So I'm going to focus on copyright and trademarks. Now, copyright is the one you'll all have heard about. It's the sort of DMCA stuff, always going on about it on YouTube and Let's Plays, and what folk can and can't do with your game, like asset stealing and copying, clone games on the App Store and stuff. So copyright is the legal right that you get automatically in a piece of work. So kind of like moral rights. And you get it as soon as you put whatever you're doing to paper. So if you're writing a script, the second you put that script down on paper, you're going to get copyright in that piece of paper. As soon as you write a piece of code, you're going to get copyright in that code. As soon as you do a piece of artwork, you're going to get copyright in that artwork automatically. You don't have to register or anything. And that gives you the right to stop anyone else coming along and copying your picture or your code or whatever. So it gives you the right to control what's done with your piece of content. So that is copyright. Oh, and just in the States, sometimes you do have to register your copyright to get extra protections, but in the UK, you don't have to do that. So in a game, you're going to have copyright, like I said, in code, artwork, UI, script, everything like that. And lastly, trademarks. Trademarks are the thing that you can use to protect your name, your studio name, or your game name, or your logo, or anything like that, any branding. And these you do have to register for. So what you have to do is you have to come up with your game name or your studio name, and then you register your trademark in different countries. So you'd get one for the UK, or you'd get one for the US, or you'd get one for the entirety of the EU. So you specify where you want to protect your name. But then you also have to specify what sort of products you want to protect your name for. So you don't just get a trademark for the name Minecraft. You don't get to just own a monopoly on Minecraft and say, if a car manufacturer came along calling themselves Minecraft, you couldn't stop them, because Minecraft's only going to be registered in relation to video games and sort of merchandise and stuff. So you pick your game name, you pick where you want to protect it, and then you pick what you want to protect it in relation to. So that's probably going to be video games and sort of merchandise, stuff like that. And there was a kind of really recent and interesting, to me, nerdily, there was these guys, Black Forest Games, they are making this new game called Diesel Stormers up there, and they had made their game and they had started selling it, and it was called Diesel Stormers. So while they were in the process of that, they were registering their game name for a European trademark. But while they were registering it, they received an objection to Diesel Stormers, and they got the objection from the guys at Diesel Clothing. So it was kind of like, why the hell are Diesel Clothing objecting to a game called Diesel Stormers? Well, when you went away and look at Diesel Clothing's trademarks, you'll actually see sort of tucked away in the products that they're protecting against, they've got like video game devices. So OHIM, the European trademark body, said, well, Diesel Clothing have technically kind of got protection for the word diesel in relation to kind of video game stuff. So they said Diesel Stormers is too close a name. So Diesel Stormers couldn't trademark the name at all. So they've now had to rename themselves, I think it was Rogue Stormers. And that could probably be disastrous. I mean, if you've already marketed or sold your game as Diesel Stormers, if you've got to change the name, it's totally crap. So try and search, if you're going to do it yourself, try and search on OHIM or the UKIPO. The OHIM is the European trademark body. UKIPO is the UK Intellectual Property Office. But because it's like, you'd never have guessed that. So it's kind of like it's really interpretive. So it's best to get like a trademark lawyer to look at it. And lastly, eek time. Employees and consultants, there is a difference. So if you are part of a dev studio, say you own your own dev studio and you've got employees working for you, then if that employee makes something for you, like any asset whatsoever, then technically, by default, legally, you are going to own the IP that they make. So if they make, let's just use like a artwork asset again, you, the employer, are going to own it by default, the IP in that. However, if the person that made that was a consultant, so you went away and you got like a random third-party consultant to come in and make something for your game, then by default, the consultant is going to own it. So if you're getting a consultant or a freelancer to make anything for you, this is why you need a contract in place, because you need to get a contract saying, I own the intellectual property in the thing you're making for me. So if I contracted out the soundtrack to my game and I didn't have a contract in place, they would own the IP in it. So if I put it in my game and I start selling my game, they could technically like hold me to ransom by saying, oh, well, my soundtrack's in your game. Give me £20,000 to keep selling it in your game. So watch out for employees and consultants. Crowdfunding, not going to really say much about this. The only thing is don't just see it as like a free source of money. There are legal relationships being formed. And if you're totally cool like me, you'll go away and read Kickstarter's terms and conditions, and you'll see that Kickstarter says, we're not involved with this at all. We'll take our cut, and then any contracts that are being formed is going to be between the backer and the crowdfunder. So legal relationships are being formed there. You are taking their money. You are promising to give them something. And if you're in the US, if you ever migrate to the US and you want to do crowdfunding, then they're pretty litigious there. There have been tons of, probably 4 or 5 cases brought against crowdfunders that haven't delivered on their stuff, and they've had fines imposed against them, like hundreds of thousands of dollars sometimes. In the UK, not such a big issue, but really it's something that could come about in the future. Yeah, I mean, you've got the kind of, an investor would be on your back more, obviously, than a backer would be, because a backer realistically isn't going to take you to court because we don't have like class action lawsuits here. But you've got to worry about, say, the marketing bodies sort of taking a look at where you've been advertising. So if you promise to make a game and then you've like frequently abused it, you could potentially be investigated by false advertising or false marketing or something like that. But you've also got the reputational risk. So on the slide, just think about it. I mean, if you totally mess up your first Kickstarter, the chances are you're probably not going to get another one. So think about the reputational risk. Tax breaks. Picture from our WoW days. Tax breaks. Headache because people are just missing out on free money. And the tax break I'm going to talk about in like 2 minutes is video games tax relief. And what that does is if you've got a qualifying video game, so that's one that's sort of British or European, and it's got to pass certain tests and stuff, but it's pretty easy to satisfy those tests, then your game can sometimes qualify for video games tax relief. And what that does is, say you've made a profit on your game, then normally you have to pay tax, like corporation tax on that profit. But video games tax relief can lower the amount of your profit. So it'll effectively save you like a chunk of money that you don't have to pay tax on. So really brief example, if you made a game for £1 million and you got back £6 million for it, that'd be amazing. So you'd have a £5 million profit, so you'd normally have to pay tax on that. But video game tax relief can lower that down from like 5 million to about 4.2 million. So you're saving tax on that £800,000 chunk, which works out to like £160,000. So you can get £160,000 worth of free money just for this. And if you make a loss, there are certain circumstances you can get money back from HMRC, which will always be good. Getting a lawyer involved too late, it's never too late, but it's certainly easier if you get a lawyer in before there's a problem, because there's so many things that can be avoided. So if you've got a proper trademark over your game, then it's going to be so much easier to stop someone using just copying your name. Or if you've got the proper contracts in place, then you're going to own the IP in your game, and you're not going to have to be held to ransom by someone that's made something for your game. And also, you're just not going to miss money on the table that you could have been claiming for ages. So find a lawyer, find the right lawyer, and just have a chat with them. I mean, it's not always as difficult as you think to talk to lawyers. Most of them. Well, most of them are difficult. So free to play, and this is something I'm going to spend probably the most of the rest of my time on. And free to play, free to kind of play. People think that because you're making a free game, then you can do whatever you want with it. People don't have any sort of rights in it because you're just like, oh, they didn't pay for it, whatever. But that's not true, especially when you've got in-app purchases. So towards the end of 2013, the UK sort of really started cottoning onto this because parents were getting like their bills through their kids spending all the money. So the UK took a look at this, and in 2014, the OFT, which is the Office of Fair Trading, they set down these 8 rules that you have to follow if you're making a free-to-play game. And then in the middle of 2014, the European Commission, so that's one of the EU legal bodies, they also set down like 4 other rules that you have to comply with if you're making a free-to-play game. And then lastly, we've got the ASA here. So that's the Advertising Standards Authority, which is the consumer protection body. And they applied these rules that the OFT and the European Commission made, they applied them to real-life games. So we've now got rules, and we've got a couple of cases of them being applied. So we've got starting to get quite a good understanding of how free-to-play is regulated. So these are the 8 principles from the OFT, and I'm not going to go through all of them. I'm going to focus on like 3. So the first one, if it's not completely free, don't call it free. Now you can't do that on the platform because Apple and Google and stuff have taken action. So you now say like git or install, you can't say free. But don't say free in your marketing either, unless it's completely free. And the Dungeon Keeper game that's made by EA, they were checked out by the ASA. And the Dungeon Keeper game, in case you haven't sort of seen it, you have to build your dungeons, and it's like a sort of traps and stuff. And in order to build things, it takes a certain amount of time. But you can speed up that time by spending premium currency. So you spend real money to speed up the building of your dungeon. But that was investigated by the ASA because it was sort of believed that, yeah, you could technically play it for free, but realistically, it was completely crap unless you paid for this premium currency to speed up the build time. It was just so slow. And EA were like, well, really, I mean, it's totally free to play. You don't have to pay at all. You just have to wait. But the ASA said, okay, that's not really true. You can't play in any meaningful way without spending money. So it's not really fair to call it free. So unless it's completely free, don't call it free. If you're making a game that is either for children or appeals to children, or would appeal to children, which the ASA or the OFT kind of defines as having bright colors or cartoonish graphics or sort of like really weird things like that. So your game, not intended for children, might appeal to children. Then there's extra things you have to sort of be concerned with. So number 6 here, don't be aggressive or exploit children's vulnerabilities to buy in-app purchases. So the example the OFT gave was if you've got a pet sim to do with a seagull. It's a really weird pet sim, I guess. If you're like trying to make a seagull happy, and you say, oh, the seagull's going to be really sad unless you pay this premium currency, unless you feed him these ice cream cones, then that would be exploiting children because they're going to be like, oh, I don't want to make the seagull sad, so I want to buy this in-app purchase. So the ASA said that's no good, or the OFT said that's no good. The extra restrictions on children's games, number 7 here, that says you shouldn't have direct exhortations on children, which in the Moshi Monsters ASA case it was a free-to-play game where there's a sort of paid membership section. So if you paid, you got access to more missions, certain sort of customizable things. And if you tried to access them without being a premium member, then a box popped up and it said, like, in capital letters, like, join now, and had a wee X in the corner. And the ASA said that that was a direct exhortation on children because it was kind of like a command to do something. They said you shouldn't command children to do anything. So they had to change that. Last 2 slides here. First one, hot topic number 1, if you're doing anything to do with gambling, then be careful. And by gambling, I don't mean where you pay to play. I mean where you pay to play and you can cash out. And I don't just mean cash out money, I potentially mean cashing out in anything that can be converted to money. So if you've got a game where you win like Counter-Strike skins or something like that, if you can sell that for real money on like a skin selling website, that might be considered money. We don't really know yet. So if you're doing a game that looks like gambling, there are extra things you have to think about. One of which is the Gambling Commission. You might have to get a license, which is expensive and onerous, and you have to do a whole bunch of stuff to comply with it. If you're doing anything with esports, then that is definitely an issue which the Gambling Commission is checking out. And you've got to be concerned about selling your games to children. So there's an ASA case recently where a gambling website had that dude on it, and they said that that was going to appeal to children. So that was like against the rules on marketing to children for a gambling game. Last thing, consumer rights. This came in on October 1st for the Consumer Rights Act, and it was the first time in the UK that consumers were given statutory rights in relation to digital content. Digital content being everything like audio files, ebooks, and video games. So everyone in the news was kind of heralding this as no more broken games. I mean, Tony Hawk's came out sort of, I think it was a day or so before, and everyone was like, oh, no wonder it came out a day before, because if it came out a day later, it'd be in breach of the Consumer Rights Act. So what does the Consumer Rights Act actually do? Well, it's probably not going to be the end of broken games, is what I'll say. It says that video games have to be of a satisfactory quality. So what's satisfactory quality? Well, again, kind of cryptically, it's defined as what the ordinary person would consider reasonable in the circumstances. So there's like so much interpretation there. What is the reasonable person going to be thinking? What circumstances do we take account of? Is it the price? Is it the size of the studio? What the heck do we have to think about here? So if you can prove your game is not of satisfactory quality, then the consumer is going to have certain rights against whoever they bought the game from, whether that's the dev or the store, Steam, or a physical store. So those rights are going to be repair or replacement. Replacement's not really relevant here because you can't really just replace a broken like downloadable game with another copy of the downloadable game because it'll still be broken. So the obvious thing is repair. But what counts as repair? Well, okay, a patch, but the Consumer Rights Act said they have to repair it within a reasonable time. So what's a reasonable time for getting a patch on a game like Assassin's Creed? I mean, what do you go by the studio size? Again, I mean, if you've got a team of 200 to 400 people working on it, does that mean you have less time? Or does it mean you have more time because obviously the game you're working on is crazy complicated? So it's going to be really, really interesting to see what this ordinary person, what a satisfactory quality is, what a reasonable time is. It's going to be really interesting to see how that impacts these kind of games that come out a bit broken on release. And if you want, there's a more detailed guide that my firm wrote that you can access there. So that is me. I'm pretty much on time.
You've got 5 minutes. So, are there any questions for Peter? Any questions? What's your going rate?
What's my going rate? I think the way we do it is we try to sort of build longer-term relationships with developers and stuff. So we normally do it on a sort of per project basis. So we take an estimate of like how long we think whatever you're coming to us with would cost, and then kind of go from there.
Question right here.
Going back to the employees consultant point that you made, if you're going in as like an unpaid intern to a studio, for example, would it be you owning what you made, or?
If you went in and you didn't have any paperwork at all?
Well, if you had like an NDA, for example, but
An NDA, a normal NDA, wouldn't transfer ownership of any intellectual property. An NDA will normally basically just say, don't say anything confidential. You probably wouldn't be considered an employee because you're not getting paid, so I don't think it would automatically transfer. It's a good question. I'd probably say, it's like a tricky question. There might be a kind of like implied transfer of the IP from you to them.
Questions, yeah?
You mentioned about the copyright. When you say about how in the UK, you may kind of go through automatically. If you sell something in America then, or does it follow their rules or still follow ours?
Copyright. So if you're selling your game, which copyright rules are going to apply?
In the UK, say anything that's made in the UK follows our rules. Automatically it has to, automatically copyrighted to yourself, you got it. And you can say in America, sometimes you might have to sign up for it. Maybe you yourselves over there, or move over there, and that sort of stuff. Do you follow their rules or ours?
Well, if you were here and you were selling your game in the States, like through Steam and it was available through the States, then you'd go by UK copyright law. So that's what you do there.
I'm aware of time, so I have one more question. Yeah, that's all.
When you say a game like Hearthstone, where you pay money for a random object, does that fall under gambling laws? Or
Yeah, that's. I've seen a lot of people draw the comparison to like poker recently.
It's in the middle.
So, you know, the money for randomized gun or skin.
Yeah, there hasn't really been any sort of application of whether or not playing the game itself is gambling. There is talk about whether or not like betting on those games is gambling, but I haven't heard of anyone talking about making the games themselves considered legally gambling. But it's definitely something that's been chatted about, I suppose. But cool, awesome.